Happy Saturday, the Sabbath today. Hello, scribers. Thank you for joining. Saturday, the 2nd of March, year of our Lord 2019, allegedly. Who do we have in the house? Let's say hello. Let me know if the audio drops out, please. I have just read out an hour's worth of text and notes on equity, jurisprudence, origin, law history, existence of maxims in law history. And it appears when Andrew said, "Are you speaking?" then you didn't realize I was reading. So that's what you get for not having the camera on. So you couldn't see me. So we'll have the camera on. I'm going to monitor it this time. We'll say hello to Explore Scotland, Turkey, and Malta. Hi, folks. We're not folks. Folks are flock, folks. So hello there, brother or sister. Thank you for joining. John, rose tinted. Let's scroll. Yes, let's scroll, scribers. I like that, John. Yes, brother. Albert, I am that I am. Andrew, you can hear me now. All right, then. So we're cracking on. I'll leave the camera on and we shall roll. House is busy. We're going into the upper sanctum. Forgive me. We're going to go. It's worth waiting for. We'll take questions afterwards. There will be a few mispronunciations of words. You don't have to bear with me. Not have to, but please, I'll ask you to bear with me. Can we do it that way? Yes, we can. I'll turn the camera off sometimes. You don't need to be seeing all this. In. Wash. Got some papers for you. Lots of papers into there. Anybody that was on Sun and Moon with us yesterday, good sort of health and wealth. Thank you. That was a truly excellent hangout. I do enjoy bouncing with brother Josh. And yes, we did have a good 2.5 hours over on Sun and Moon with Sister Karen yesterday. So I will link the video to this channel later today. Here we go. We are live. Let me check it. Can leave that there. Right then, let's get down to business. Origin and history of equity jurisprudence. I'm going to read you the distinction between equity and law, some history, causes of the existence of the equity jurisdiction, separate equitable tribunals, equity jurisdiction in the United States. So if you are an able danger recent scriber, splspro.com, brother or sister that's joined us, firstly, let me say thank you, peace and love from me to you, gratitude from the heart, from the mind, from the prana, out that way. Thank you for joining. Thank you for programming and yourself and self-initiation. Here we go. The origin and history, equity jurisprudence, and the distinction between equity and law history, you know, all of that encapsulated. So the distinction between equity in a technical sense and law is a matter not so much of substance or principle as of form and history. Equity, in its technical sense, as used in connection with that system of law known as equitable jurisprudence, means neither natural justice nor even that kind of natural justice which is capable of being judicially enforced. There are many matters of natural justice which cannot be, or at least are not, enforced in any court, either because of the difficulty of framing general rules to meet them, or from the doubtful policy of attempting to give a legal sanction to duties of imperfect obligation, such as charity, gratitude, and kindness. Even positive contract obligations barred by the statute of limitations and promises not founded on valid consideration are not enforceable at law or in equity. So too, the administration of natural justice lies largely within the competency of courts of law, which often proceed as far as the nature of the remedies they administer will permit. On the same doctrines as courts of chancery, Natural justice or equity in its larger meaning is often covered by legislative enactments, and to that extent is therefore excluded from equity in a technical sense. It is in view of these facts that equity, as used in the language of English law, has been so defined or rather described by modern equity writers as being that kind of natural justice which, through of such a nature as properly to admit being judicially enforced, is not enforced by common law courts, an omission which is supplied by the courts of equity. So I would like to explain here the way that I and others see this within our realm and with our in our family at the minute is there is a law, land, air, and water. Okay, now we're going to break down the land, the air, and the water. The law of the land would be man in his private, sovereign, self-governing capacity. Okay, and you would be trading, levying, and bartering would go with that, but trading is the key word. Trade. Um, Land, air. Air is ecclesiastical Vatican involving trust management. When myself and Andy Sovereign Smith was down at Liverpool, Alderhay, we asked from the black Catholic priest there to be the eyes and ears of the Holy See and to enact the Holy See to give David, brother Andy, and the family there the baby, the asset rites of passage through the Holy See, and that's exemplary. First, our knowledge of what we asked for and what we got, but we wasn't able to conduct and carry out due to denial of authority from the grantors, English owners, grantors, testator. We've got lots of OR, mortgagor, and then we've got the EE, so OR, England grantor, executor, executive, certain words correlating America, settlor, settlement, settlors. That's your position. So the air, ecclesiastical, Vatican, trusts, the water, admiralty, maritime. You've got your UCC, and you've got the ecclesiasticals are up in the air, admiralty, maritime, contract, public, UCC, waters, admiralty, commerce. Then, so that's your commerce and that's your public. So there's your land, your air, and your water. In that context of governance with the parameters we have dipped in, we are able to say, and we've used and gone further than most have on YouTube. Not the furthest, but we're able to put hand on heart and tell you how we see it. So we are recognizing at quite a vast rate the jurisdictions and jurisprudence of many and various. So man and land, trade and private is what you would take from that, I would hope. We've got some citations, references. I'm going to give you a few, and the publication is available to download on the .com. We are increasing the publications there for the research, development, and education of this realm. So, supplied by the courts of equity, and then we went to where the court held the statute of frauds to be as binding on courts of equity as on courts of law, except when it is being used as an instrument of fraud. That is defines equity as those doctrines and rules primary and remedial rights and remedies which the common law, by reason of its fixed methods and remedial system, was either unable or inadequate in the regular course of its development to establish, enforce, and confer, and which it therefore either tacitly omitted or openly rejected. The jurisdiction of the courts of chancery now extends to all civil cases proper in good conscience and honesty for relief or aid, as to which the procedure of the common law courts is unsuited to give an adequate remedy, or as to which the common law courts were, when able to extend their aid, have refused to do so. Judge Phelps of Baltimore, MD, defines equity as follows: by Juridical equity is meant a systemic appeal for the relief from a cramped administration of defective laws to the disciplined conscience of a competent magistrate, applying to the special circumstances of defined and limited classes of civil cases the principles of natural justice, controlled in a measure as well by considerations of. So what do I want to add there? Common law. When we say common law, we mean harm, injury, and loss, and also we mean common law, harm, injury, and loss, and then we also mean the mandated statutory codes that are, coming out of Westminster under assumption and presumption upon your person. So when we say common law, as we've explained before in our Anglo presentations and hangouts and so forth, we have two-tier, if not a three-tier of the common law system, where you have the common law, harm, injury, and loss, which everybody is governable to under default, and then you have the common law Westminster codes, federal, penal for the Americas. This is an American publication, so it's going to have American references about the movements of the Privy Council and the courts of chancery over here on Anglo, whilst the judicial realm is adjusting and being established over in America. So you have to bear with me for a certain amount, but as long as you get that the common law, when you are thinking common law, you need to be thinking penal and statutory, not the harm, injury, and loss, and bear that in mind with the correlation of. All right, thank you. Inadequate, right, and irregular. So we got considerations of. It may be easily seen that this definition or description is meaningless without some knowledge or understanding of the origin and development of the extraordinary jurisdiction of the English Court of Chancery and the relation it bore to the English judiciary. The importance of the history of the Court of Chancery is not diminished by the Supreme Court Judicator Act of 1873 and its amendments, which abolished the distinction between courts of equity and courts of law. By that act, equitable principles were preserved and applied to the administration of justice in all courts. Shadow Dynamics, 1873, Adjudicator, what you're saying, we've mentioned this before. Yes, you've brought it up, I have. Historical origins. Nor is this history of less importance to the student of equity as it exists in the courts of our own country. In a comparative, laws, trust, right, private, express, trust, laws, big shout going out to a man like Barry for the chat the other day, governable by the laws of England and Wales. So the laws of England and Wales, okay, then you've got the laws of the United Kingdom. So we would argue that to publicly commit commerce in admiralty with the sea people as the person in commerce, laws of the sea, as I've explained previously, that would be one way, public commerce and that governance. Then you have the trade, man, and private on the land, of the land in our country. So when we speak of country, England and Wales, Britannia, Anglo, many names for this landmass. Okay, so we have to be careful when we call it the country. Laws of England and Wales, you'd argue, would be the common law side of it. The laws of the United Kingdom. See, we do go quite a way to separate out. If I make a mistake, that's why I tell you to check. None of this is copied. It's from a publication, and I'd like to read you an excerpt for educational and entertainment purposes. Clarification, substance over form. And to correlate what brother Andy is doing over in America with the American brothers and sisters over there, we'd like to give you a little boost and a thank you and some information to help you in front of what may be happening later down the line in March in Wales. In a comparatively recent case in the United States Supreme Court, it was held that the equity jurisdiction conferred on the federal courts is the same as that possessed by the High Court of Chancery. One of the rules of the Supreme Court made under the authority of an act of Congress, what exactly, is that when not otherwise directed, the practice in the High Court of Chancery in England shall be followed. In many of the states, the common law and chancery jurisdiction is exercised by the same courts. but without changing the essential distinction between legal and equitable principles. In other states, separate common law and equity tribunals have been retained, while in others, equitable principles are administered by means of common law or statutory forms. Disgusting. It's not funny, but it is funny to read it really when you see that. Public policy, as by established precedent and by positive provisions of law, Phelps, and then we've got quotes, says that equity jurisprudence may be properly be said to be that portion of remedial justice which is exclusively administered by a court of equity. As contradistinguished from the portion of remedial justice which is exclusively administered by a court of common law. Blah, blah, blah states that equity is a system of justice which was administered by the High Court of Chancery in England in the exercise of its extraordinary jurisdiction. And then we've got a lot of citations here for America, a lot of them. Basie versus Gallagher will be the one that I'll read out because that's simple and enough. Okay. Origin and history. Principles as administered by the Chancery Courts in England are still recognised and applied unless inconsistent with the statutes and constitutions of the states. We'll talk about the Privy Council and how women were introduced into the law. There was once a claim in the history, and we'll go about 1860, maybe 1960. I'm going to paraphrase. You do your own due diligence, but the basic bare bones of it are a lady wanted to perhaps bring a claim in law. Once the legal system received that claim, they wasn't able to deal with it because up until that point, ladies' female form had not been brought into law. So we'll say it would be Canada that this happened in. And this lady was brought forward, and the courts had to write from Canada to the Privy Courts of London. And that's essentially, as I understand it, how the first female was brought into the legal realm and the female form. So there's something there to be recognised as well, and what happened and how late on. None of this is thousands of years old. It's within, hundreds of years. So it is quite relevant, and you'll see the kingship, judgment ship and kingship correlation as I go through, all right? But that's just something I'd like furthermore to recognise. And man being born first in time is first in line. It must be said that way, as you'll see by the equitable maxims and legal lawful maxims I'll bring out later. Man is born, say, the 5th, 6th, 7th, 8th, 9th of May. Registration is on the 25th, 26th, 27th, 28th of May. Now, there's argumentation of who is the name, who owns the name, who's done what with what name. Well, I'm not a name. I cannot be a name. How can I be a name? I use a name. I was given a name. I used to be a DJ. Now I'm a party. What? Yeah, I know. I'm not doing it on purpose, but I used to DJ. Now I'm a party. David and Jeremita. So the name given to me to use, commonly known as the Fool, Crazy Horse, David, Indie, DJ, too many names. Depends what part of the landmass and where I am in the realm to what they call me. In Greece, Ella Malaka, So Ella Malaka is not mine. I don't own it, but it's hello and a naughty word there. If you're Greek, you'll know Mediterranean. You'll know that word. So the name, let's get back to it, has been capitalized on. I was here first on the 9th, 8th, 7th, 6th of May. The registration and the claim of right and the bondsman appointment for the state and handing over under the 1302 unum sanctum, Eterni Regis, convocation, 1666. That was done. Subsequently, some days after, man entered the realm. So, first in time is first in line. I would argue, I'm going to argue equitably, that your public, constitutional, legislative, penal crap can go to one side there. I would argue that first in time means that I have rights to the name, and I will call the equitable right to the name. I can prove that man was here first. I was given that name at the age of 0, and then some days later, the state claimed that name, capitalized on it, and through non-disclosure and abuse of trust, breach of trust, we would argue, but maybe it's in honor to protect us till we're old enough to work it out. Either way, non-disclosed acts was done. It was set up, and here we are today. Now we're arguing who is the name, who owns the name. I hope that clarifies a little something there for you. It's always simple answers to the solutions of these overcomplicated things and situations that we're seeing and having put to us, whilst we're looking at noticing, appointing secretaries and generals and so forth of this present military we find ourselves in, by order, we would argue, of the Italian boss. We have the papal sees, the bull papal, the current sees, the paper sees. When we go on about the paper sees, papal, bull papal, paper proclamations, doctrines, notices, I hope it is now dropping and clarifying and segmenting, and we're going to continue. It's all important for how we are. I'm sorry, but I'm now going to stick to it. Defines equity as those doctrines and rules primarily and remedial rights and remedies which the common law, by reason of its fixed methods and remedial system, was either unable or inadequate in the regular course of its development to establish, enforce, and confer, and which it therefore either tacitly admitted or openly rejected. The jurisdiction of the courts of chancery now extends to all civil cases in good conscience and honesty for relief or aid, as to which the procedure of the common law courts is unsuited to give an adequate remedy, or as which to the common law courts, when able to extend their aid, have refused to do so. Have I read that out? Yes, I have. No, I haven't. I can't remember. Judge Phelps, Baltimore, a distinction between equity and law history. It may be seen easily that this definition or description is meaningless without some knowledge or understanding of the origin and development of the ordinary jurisdiction. What we're saying, bad signal where I am, sounds all right. Yes. All right then. The importance of the history of the Court of Chancery is not diminished by the Supreme Judicature Act of 1873 and its amendments. I did get to there. Which abolished the distinction between the courts of equity and the courts of law. By that act, equitable principles were preserved and applied to the administration of justice in all courts. Nor is this history of less importance to the student of equity, that's familiar, as it exists in the courts of our own country. In a comparatively recent case in the United States Supreme Court, equity jurisdiction, federal courts, I got that. I got high courts of chancery shall be followed. In many states, the common law and chancery jurisdiction is exercised by the same courts, but without changing the essential jurisdiction. I got that bit. All right, then the judiciary of early Norman England, the general scheme of judicial organisation existing during the realm of William the Conqueror, did not materially form. It had been under Edward prior to the Norman conquest. So we'd look at the 1066 now, the land tenure and the Domesday Book as well in this era, in this age, all right, historians amongst you. The shire or county courts, the 100 motes and borough courts together with the hall motes, manor courts or courts baron of the king and the Norman lords, continued to be the ordinary courts of civil jurisdiction. The supreme judicial authority was vested in the king, assisted by his councils. William appointed a chief justiciary to preside over all pleas and suits heard in the Cura Regis, which then for a considerable time afterwards was a body composed of barons and high ecclesiastics with legislative, judicial, and administrative functions. Professor Pomeroy, in his treatise on equity jurisprudence, says that his creation of a permanent judicial officer, off-ISA, was the germ of the professional common law tribunals having a supreme jurisdiction throughout England, which subsequently became established as a part of the government, distinct from the legislative and executive. The judicial business of the Curia Regis was not separated from the legislative until the reign of Henry II. This was done by assigning the legal work to certain members of the King's Court or Council, who formed what was called the Aula Regis, A-U-L-A, Aula Regis, From the time of this separation until the enactment of the Supreme Court Adjudicator Act of 1873, the Aula Regis, or as it was afterwards called, the Court of the King's Bench, continued to be the highest common law tribunal of original jurisdiction. William the Conqueror, appointed as occasion required it, certain of his justices to preside over the country or 100 courts of the several provinces, and suits which would otherwise have been tried in the King's Court were transferred to the courts so constituted. These justices were normally the King's representatives and were appointed to administer or superintend the administration of justice. But they were really, in many cases, the instruments of extortion and injustice. Really? Sounds ringing true there, doesn't it? Following this practice, itinerant justices or justices in air, E-Y-R-E, air, phonics for air, E-Y-R-E, were occasionally appointed by Henry I to go from county to county to hold pleas, civil and criminal. The practice became permanent in the reign of Henry, King Henry. Justices of Assize and Nisi Prius, yeah, Nisiprius, Prius, and of Gaul, Gaol, delivery were appointed in the reign of Edward I to hold sessions of justice in these provinces. Additional powers were given to these justices and improvements made in their proceedings, which superseded the necessity of the appointment of justices in air, and none were appointed after the 10th year of the reign of King Edward, as a consequence of these changes in the administration of justice in the provinces. Almost all the judicial business of the country was driven into the King's Court, and the county and 100 courts ceased to exist for the purpose of determining controversies between litigants. The King's Court followed the King in his journeys to different parts of his kingdom. We have covered, and at the seminar in York, I did read out the history of equity and the equitable lawful maxims, some canon stuff, and we have covered this, very, very extensively. And it is now called the Queen's Bench. We have the 3 publications of the Sovereign Masters Guild Key Competence, the foundation level, and the bronze, silver, and gold. You've got the 3 courts there mentioned that we would say for obviously England Queen's Bench, the Chancery Division now, and what they do in the courts of Chancery. Then you've got Australia and America. Your likened courts for that are mentioned and referenced in those publications as well. So we have covered quite a lot of this, and it's just further cementing what we've already done and what Sovereign Smith has brought between the Americas and the Anglos now. And we just basically, I need to bring some of this to you again. The King's Court followed the King in his journeys to different parts of his kingdomship. Okay, it's a kingdomship. It's a lordship, so kingdomship, township. All right, these are all ships. And just because it's a kingdom doesn't mean it's not a kingdomship, a lordship, a scholarship. All right, so we'll say these words properly. And we're going to interject Josh X's help, what he's given me so far, and the work that we've constituted together over the last few weeks and months. This resulted in great inconsistence to suitors, ending OR. Yes, suitors, SUITORS, which was sought to be reminded by one of the articles of Magna Carta, which declared that common pleas should no longer follow the king. Thenceforth, justices were appointed expressly to hear and determine pleas of land, justices of the peace. We would call them just ices, all right, off icers. A just ice, an off ice. Yes, with a judgeship. This branch of the King's Court was fixed at Westminster, and the dates of the origin of the Court of Common Pleas, perhaps the oldest of all courts emanating from the Curia or Aula Regis, was the Exchequer. This was a board or court. Henry II divided the kingdom into 6 parts and chose as justices prudent and discreet men, what? Noble, prudent, and discreet men, okay? These justices, perhaps they were at that time, we'll carry on. These justices went from county to county and held pleas, civil as well as criminal. The justices in Eyre heard, amongst others, common pleas in their courts. This was an appeal from their decisions to the King's Court. In all cases, they had to give an account of their proceedings, which for this purpose was regularly entered in the rolls. Master of the rolls, the manor rolls. There's lots of rolls here. Rolls Royce, yes. Suits, you wear a suit, you are a suitor, yes. Commerce and suits. So we continue on. Established by William the Conqueror to superintend and manage the royal revenues. To this board or court were added the chief justiciary and the chancellor, and such barons and dignitaries of the church as the king selected for the purpose, who attended to judge the law and determine all matters of doubt. At first, the jurisdiction of this court was confined to the decision of causes connected with the revenues, but its authority was subsequently enlarged by the use of a legal fiction, the plaintiff being permitted to allege that he was a debtor to the crown, and the aid of the court was invoked to enable him to recover from the defendant what would enable him to pay his debt to the crown. Ooh, very, very. So I hope this is cha-ching. In this way, to a certain extent, the jurisdiction of the Court of Exchequer become concurrent with that of the other superior law courts. You can take that and run with it. The Court of Chancery. The Court of Chancery, in the exercise of its ordinary or common law jurisdiction, is of very high antiquity. When the Aura Regis, or King's Court, was broken into pieces and its jurisdiction distributed among the several courts as above designated, the Court of Chancery received its portion. At that time, it is apparent that the Court of Chancery did not exist as a court of equity, as distinguished from a court of law. Under the early Norman kings, there existed a select council, always in attendance on the king's person, all right? The king's person, corresponding to what is now termed the Privy Council. That's why I told you that little bit about the woman in the Privy Council and what part they played to parties. The Select Council consisted of certain great officers, who were members ex officio, EX space OFFICIO, as the Chancellor, Treasurer, Grand Justiciary, and Justices of the other courts, and such others, usually barons, earls, and bishops, as the king might name. In early times, probably down to the time of Edward III. This council, presided over by the king himself, discussed and decided upon applications for the exercise of the royal prerogative in regard to the matters of judicial cognizance. We're going to get to the praetor in a bit. Smithy's brought a word out, okay, and I know I'd read it somewhere, and it bothered me that I heard. It didn't bother me, but it does bother me when I hear YouTube tell me a word. I'm like, what's that mean? I'm not sure I know that one. I don't think I've used that one. I don't think I've written it. I remember. Oh, I do remember reading it. I remember reading it in the publication. 750 odd pages, just one of these publications has got. And this is just a 5-page excerpt from that. So we have got a lot to troll through. When we can digitally reference and research and find it and keep Control and F and find praetor, then I can know where to go without reading all 750 pages. The Indigos do have quite a technological niche on this law renaissance at the minute. So, yeah, praetor, it's coming up in a bit. Get ready. At first, the jurisdiction of this court was confined to the decision of causes connected with the revenues, but its authority was subsequently enlarged by the use of a legal fiction. I've got that. All right. The Court of Chancery, done that. Edward III, all right, we've got that. All right, then. So we're going to the Great Council of the King, which afterwards became Parliament, all right, ment. Ment is mind, mentee. Also posed and exercised on petition certain judicial functions. If it were impossible for the applicants and petitioners to obtain a remedy in the common law courts, their applicants and petitioners were transmitted to the councils, it says here. It is apparent that the Chancellor was the principal officer with reference to the judicial business which the Select Council, as well as the Great Council, had to advise upon or transact. It early became the custom of the king to send certain petitions addressed to him, praying for extraordinary remedies to the Chancellor and Master of the Rolls, or to the Chancellor alone. When the Chancellor administered relief independently of the council, it was by express delegation from the king and given as it would, full stop. Oh, we're still giving the audio. Come on, choob. Yes, we are. This council had an absolute jurisdiction over all the proceedings in the courts below. If any litigant felt himself aggravated, he applied for redress, REDRESS, to the council in the same manner as he would have applied to the king before the latter committed. His prerogative of disturbing justice and equity to his council. The business of this council out of Parliament may be reduced to two heads: its deliberative office as a council of advice and its decisive power of jurisdiction. With respect to the first, it is obviously comprehended all subjects of political deliberation, which were usually referred to it by the king, this being in fact the administration or governing council of the state, the distinction of a cabinet being introduced in a comparatively modern time. There was likewise a vast number of petitions continually presented to the council, upon which they proceeded no further than to sort, as it were, and forward them by endorsement to the proper courts, or advise the suitor what remedy he was then to seek. Thus, some petitions are and were answered. This cannot be done without a new law. Some were turned over to the regular courts, as the Chancery or King's Bench, some of greater matter were endorsed to be heard before the Great Council. Some concerning the King's interest were referred to the Chancery or select persons of the Council, houses in Parliament. If the matter were remediable at law, no. If the matter were remediable at law and there were no obstacles to the remedy being obtained, the petitioner was sent to the common law courts. If it were a matter of revenue, or inland revenue, taxation, fines, fees, forfeits, he was sent to the Exchequer. If the matter related to the King's grants, grantor, grantee, grants, or was cognizable under the Chancellor's ordinary jurisdiction, he was sent to the Chancery. Seen by the advice of the Council, gradually judicial business of the Council of a civil nature was assumed by the Chancellor as the keeper of the King's conscience. We've mentioned this before. This is going over again. There's no new words here for you. And its chief judicial officer. The inadaptability of the Council for the transaction of judicial business made easier this assumption. The exercise of judicial functions by the King, the Select or Privy Council, and the Great Council or Parliament makes clear the fact that the common law courts were clearly insufficient, even in their infancy, infantry, militant, for the needs of the country, and that there were civil rights which such courts could not protect. We call them unalienable rights, okay? Get to know. The earliest general reference to petitions to the Chancellor is found in Ordinance of blah, blah, blah in the year 1280, complaining of the multitude of petitions presented to the King, which could properly be dealt with by the Chancellor and judgeships, yes, in the judicial realm, and providing that all petitions that touch the seal, the Great Seal, the Holy Seal, the seal is sacred, what seal is this, shall go first to the Chancellor, and those relating to other subjects shall go to the Exchequer, the Justices, and other tribunals according to their nature. It thus appears that during the reign of Edward I, it was not yet a fixed practice to send to the Chancellor all petitions coming before the King or his councils, which could not, in the first instance, go to the common law courts. The practice of delegating cases coming with the prerogative judicial jurisdiction of the Crown and its councils to the Chancellor for his sole decision, Chancellor, O-R, another one, for his sole, S-O-L-E, decision. Having once commenced, rapidly grew until it became the common method of dealing with such it's not good for you. See Josh and me chatting. Verse, universal, controversies. In the reign of Edward III, the Court of Chancery, as a court of ordinary jurisdiction, became of great importance, but the Chancellor, in the exercise of his common law, it is probable that the judicial power of the Chancellor as a law judge and his consequent familiarity within the laws of the realm and experience in adjudicating were the reasons why any case which appeared to the King's judicial prerogative and for which any cause could not be properly examined by the Council was naturally referred either by the Crown or the Council to the Chancellor for his sole decision. Decision. Not in his public office, his sole decision. Very important key words there. Appeal, repeal, dispute, whatever may have been the motives, it is certain that the Chancellor's equitable jurisdiction commenced in this manner. Ordinary jurisdiction could not avert to matters of conscience, and it still can't. It would not. It would, nevertheless, seem that it was during this reign that the Court of Chancery first existed as a district court for giving relief in cases which required extraordinary remedies. Edward III was a busy king. Well, was he? I'm a busy man. Know how he feels. Edward. Fist bumps of the temporal, spiritual realm. He was a busy king, engaging himself in numerous foreign enterprises and therefore unable to attend to the many petitions which were presented to him. Consequently, in the 22nd year of his reign, he, by a writ of or ordinance, referred all matters as were of grace, G, God, 7, race, Josh X, thank you, brother, gematria, G, race, to be dispatched by the Chancellor or Keeper of the Privy Seal. It is generally considered that the Court of Chancery owes its existence as a regular court for administering the extraordinary relief and equitable remedies to this or similar ordinance, does it not? Some story quotes Wooderson as deducing the jurisdiction from same source, saying great stress on the ordinance above referred to and also on the statute of which he considers as referring many things to the sole and exclusive cognizance of the Chancellor. And he adds that it seems incontrovertible that the Chancery exercise an equitable jurisdiction, though its practice was, perhaps, not very flourishing or frequent throughout the reign of Edward III. Newham Davis says, origin and nature of equity to jurisdiction in 1348 by the writ of 22 Edward III. It was enacted, what numbers, 1348, writ 22 Edward III, 3 there, 3 lines, 3 ones, Edward 111, Edward Woodward, Edward, yes he would, Doug, what a Doug, oh wow, what a wood chuck, what a wood chuck. Edward III. It was enacted that all matters of race, grace, and favour were to be referred to the Chancellor and to be dispatched either by him or the Keeper of the Privy Seal. This was the great step which recognised the equitable as opposed to the legal jurisdiction of the Court of Chancery, although the distinction was not finally established until the following reign. From this date, the Chancellor possessed an independent as well as separate jurisdiction. The ordinance or proclamation above referred to ran as follows. The King to the Sheriffs of London, greetings. For as much as we are greatly and all daily busied in various affairs concerning us and the state of our realm of England, we will that whatsoever business relating as well to the common law of our kingdom as our special grace, cognizable before us, from henceforth be prosecuted as followeth, viz., semicolon, the common law business before Archbishop of Canterbury elect, our Chancellor, by him to be dispatched, and the other matters grantable by our special grace, be prosecuted before our said Chancellor or our well-beloved clerk, the keeper of the Privy Seal, so that they or one of them transmit to us such petitions of business which, without consulting us, they cannot determine together with their advice thereupon, without any further prosecution to be had before us for the same, that upon inspection thereof we may further signify to the aforesaid Chancellor or keeper our will and pleasure therein, and that none other do it for the future. That's powerful statement. That's some, well, my arms, they're standing up. And no other, and that none other do for the future appear, however, that matters of grace involving equitable relief and remedies were at this time exclusively sent to the Chancellor at this time. Key moment there, not now. History at this time. American publication reflecting the Great Council of Parliament and the Privy Council still exercise an equitable jurisdiction by delegation from the sovereign. Now, the sovereign, that would be whom? It's American publication, so it's going to be referencing QE2 there, or the king himself. If it was now, it would be Queen Elizabeth in the capacity of one of the crowns, the Crown of London, crown in the Vatican, the tri-state crown here. We know there are 3 crowns. So the sovereign would have been the king at the time, as I've mentioned there. Edward III, 311s, Edward Woodwood, would a woodchuck, chuck, what a woodwood chuck. And the Privy Council still exercise an equitable jurisdiction by delegation from the sovereign. We'll say Edward III, the king, the monarch, okay, the arch, the archy, the monarch, the archon. There you go. From this, the Ark of the what? Exactly. From this time, suits were brought before the Chancellor by petition or bill, without any preliminary writ. If on the presentation of such petition or bill, the case called for extraordinary interference, a writ was issued on the command of the Chancellor, the command, who gives commands, but in the name of the King, by which the party, the DJ, the party complained. What are real sovereigns? Please stand up. Please stand up. Against was summoned to appear before the Court of Chancery to answer the complaint and abide by the order of the court. In the reign of Edward III, the Court of Chancery ceased to follow the King. It was during the reign of Richard II that the Court of Chancery was established as a distinct and permanent court, having a separate jurisdiction within its own peculiar mode of procedure. From the time of the reign of Henry VI, the equity jurisdiction of the court constantly grew in importance, and in the reign of Henry VIII, it expanded into a broad and almost boundless jurisdiction under the fostering care, nanny state, the fostering care, the husbandry role, the ambitious wisdom and love of power of Cardinal, it says Wolsey there, pursue such kind of business before us, we command you immediately upon sight hereof to make proclamation of the premises. By the statute 17 Rich 2 C6, it was enacted that where persons were compelled to appear before the council or the chancery on suggestions found to be untrue, imtrue, improbable, impossible, I'm possible, true, I'm true, found to be I am, indigo, Mikey, tango, Romeo, uniform, echo, true. The Chancellor should have power to award damages according to his discretion. From time of the passing of this statute, the Court of Chancery was established as a distinct and permanent court, having a separate jurisdiction. Right, so now we need to say statute, chancery managed by, and persons, private business for persons also have the capability to go one further and make an appointment with them, and you would present in a totally different way with the equitable instrument, the equitable relief should be given, and other such things of claims of rights and equity cards are us, you know what I'm saying? So while we mentioned that there are legislation and statutes, the Court of Chancery was established as a distinct and permanent court having a separate jurisdiction. This statute was a solemn recognition by Parliament of the court as a distinct and permanent tribunal having a separate jurisdiction and its own modes of procedure and of granting relief, and the enactment was an important event in the legal history of the Chancery story. So that just hits home to you what we are saying, why we are saying it, and what we are bothered in. And the masters of the rolls, the masters of the courts, the masters chambers, the stars, 50% claim going up to these courts, they're obliged to help you with it. Thank you, Sovereign B, for that little bit there that you're putting in. I'm not giving too much away. I am obliged to everybody that sends me documents, PDF, information, and so forth, not to give everything out because of the damage and the calamity that can follow through getting this mixed up and half doing it with half truths and whole lies. So we have to just follow the process. It pains me how slow it is and how far behind we are with it. If we can get sponsorship, endorsement, and moving forward this year, this is what we're getting on, okay? So just bear with us, hear us out, work with us, and continue to learn by proxy and passiveness. The equitable jurisdiction of the Court of Chancery owes its origins to A, the inflexibility and rigidity of the common law, B, the inelasticity of the common law system of procedure, and C, the ineffectiveness or inadequacy of the remedies provided by the common law. Inflexibility of the common law. It is frequently asserted that the principles of common law are founded on reason and equity. Doubtless, this is, in a sense, true, so long as the common law was in the course of formation. It was not only susceptible of application to cases within the spirit of existing law, take note, but not expressly provided for, but also of being applied in accordance with the principles of equity as subsequently known. Precedents established by the decisions of the judges soon came to be considered as of binding authority on succeeding judges. Hence, early in its history, the English common law became essentially a lex scripta. See the publications and the documentations which are entitled the Governor's Master's Trust document, and then the one we found on WordPress with the Justinian deception and the Vatican outline of the governance of the master-servant slave principles, Romilly Stewart, Gloucester Channel, Justinian deception. We love you. Thank you for that. We claim none of that work. We present it in accordance with our education and under the covenant. I'm looking to speak to Romilly, the man. If anybody can link me up, it needs to be done. We are moving fast and in many ways, but this one has been a long time coming. Creditor certificate, Secretary of State, sovereign countries, Venezuela, Jamaica, birth certificate, authenticated, Secretary of State, some other subsequent moves that I'm going to leave out on purpose, getting it back, Staples too, against Dave Richards, notice, public notary, and so forth, and trickery and others, going to the back of the certificate, public, private, bonding, and so forth, ecclesiastical deed poll. We have got another option, a different way, international commerce, birth certificate, authenticated, registered for use of trade in a sovereign country, pins in everything. We got loads for you this year. Trust me, it can't come out quick enough. Working an involuntary servitude 40 hours a week and having to cram this in and do what we're doing is just personal torture. It's torture it's, to me, it's personal, and it's on the man. It's inflicted, self-inflicted through our ignorance. 41 now. I've just completed 40 years in the wilderness. We're going back for re-leaf. And when a tree has leaves, they leave the tree. They're called leaves. Josh X, again, big love. Now we're going for equitable remedy, cure, and maintenance, and equitable relief, not equitable interest. Fixate less on the interest, cut the instruments, equity instruments, relief, leaves, going back to the tree, naked tree, going back and becoming one with the mother tree, the mother root, the original source. I cannot get what you said to me yesterday, Josh. I'm tingling with it. The Walking Dead are going back to being alive. Dominion, all these massive things. Glosser, Romney Stewart, one of his videos, Cognizance, Remedy, Ledger, one of them he says, you're at the tree of knowledge and the tree of life. And Eve, Apple, icon, biting, technology, iPad, Apple, bite, Eve, biting, Apple, knowledge. We are now relieving back to the tree of life, original source. Look at the cabal, the tree that on many levels, the G and the grace, G race, G7 race, 7G God, R ace, and there's so much more to come. Sunday, hanging out tomorrow with Josh on an evening. I've invited Kev and Andy to come along. And hopefully G-Star can be on the chat room. That is the Phi cycle, the physical five are going to be there with you tomorrow. We're going to expand on anything that you might be interested in or that you're taking from this. When I say we're confident and strong, this is how confident and strong we are. We are dividing right now the minds of man because the time is now, and what's going on needs urgent, immediate attention. Urgent. So there you go. That was the causes of existence of the equity jurisdiction, and there was the A, B, and C. Inflexibility of the common law. It is frequently asserted that the principles of common law are founded on reason and equity. Doubtless, this is in a sense true, so long as the common laws was in the course of formation. It was not only susceptible of application to cases within the spirit, that's the key word there, of existing law, but not expressly provided for, but also being applied in accordance with the principles of equity, as subsequently known. But precedents established by the decisions of judges soon came to be considered as of binding authority on success, and we've covered all of that. Had it not been for the blind conservatism of the courts of King's Bench, Common Pleas, and Exchequer in their regard for the rules and doctrines once formulated by precedents, and their inability and unwillingness to furnish remedies for such wrongs as by their nature would permit of redress, the reserved jurisdiction of the King's Council would probably not arose out of the inability of courts of law through the inflexibility of their rules and want of power to adopt judgments to the special circumstances of cases to reach and complete justice in all cases. Thomas versus musical MUT protective union 121 N.Y.45, 24 N.E.24. Have a look at that. Origin and history continued. The distinct equitable jurisdiction of a court of chancery would never have been created. Mr. Green, in his History of England, says the equitable jurisdiction of the Chancellor sprang from the defective nature and technical unbending rules of the common law courts on the petition of a party for whose grievance the common law provided no adequate remedy. An analogous extension of his powers enabled the Chancellor to afford relief in cases of fraud, accident, or abuse of trust. And this side of the jurisdiction was largely extended at a latter time by the results of legislation on the tenure of land by the ecclesiastical bodies. It may be correctly assumed, when you assume you make an ass out of you and me, that the ultimate source of equitable jurisdiction was in the King's prerogative to administer justice, the King's conscience, yes, independently of the courts. We have now seen how the common law and equitable jurisdictions of the Chancellor arose from the custom of the King and his council to refer matters pertaining to the administration of justice to that officer. But it is also true that the exercise of the King's prerogative would have been often required had the common law courts been able or willing to provide a remedy for every wrong. Many injuries existed which the common law courts could not relieve. The suitor was therefore, in such cases, compelled to throw himself upon the grace and compassion of the King and council. Well, we are no longer compelled to throw ourselves upon the grace and compassion of the King and the council. We are now compelled to compel you in your fiduciary capacity under your new appointment in the correction of the trust relieving us as legal title, going to equitable title, putting you, justice, CEO, CFO, etc., into the trustee position as correctly done. You was operating in a trust position before, so you can operate in a trust position now. If you're going to start disclaiming your duties, we will then move forward with the claims for damages. You accept this new appointment. I will now be grantor, yes, set law for the US. The person may be the beneficiary. There may be another beneficiary. Yes, this may be, well, talked about later. So, when the equitable jurisdiction of the Court of Chancery became firmly established, he was required to seek relief in that court. The equitable jurisdiction of the Chancellor grew up in the same manner and under the same circumstance as the equitable jurisdiction of the Praetor. There we go. It's all, I've left it right till the end. I've worked you all the way through that, and I've done some lyrical kung fu there just so I can get that word in for you, all right? It was brought to you by brother Andy Sovereign Smith when he was across the, realm on casting on other channels, and a shiver went down my spine when I heard that word. A download happened, and I went, "What? Praetor, pray at or I like that. Pray, yeah, but Praetor. So we go again. We go again. The equitable jurisdiction of the Chancellor grew up in the same manner and under the same circumstance as the equitable jurisdiction of the Praetor at Rome. The Club of Rome, remember them? Alarm bells ringing. Each of them arose from necessity in the actual administration of justice and from the deficiencies of the positive law. There's indications into the pyramid of law and what positive law is and isn't in the foundation publications we've done for you there. The lex scripta, or from the inadequacy of the remedies in the prescribed forms to meet the full EX and G of each particular case. It was not a usurpation for the purpose of acquiring and exercising power, but a beneficial interposition to correct gross errors, misconduct, claims. Finished. There's these. We've got these. It goes on. It actually goes on. And I'll take a break. We'll go to comments and then we'll hop back in. All right. Thank you for the 23, John. Explore. It never happened. Lisa. I am that I am. Shadow. Albert. Jerry. Bad signal. Got that, John. Encyclopedia. All right. John. What you saying about a forum? Not got bad leg. Ewok, hello. Andrew. Servitude. Shame, but all right, brother. We'll pray for you. John. Greg. Good day. Easy G-Star. Might want you tomorrow evening so you can be part of the Phi Cycle if that's all right. Probably about 8:30, 9-ish. Chill Star. All right, then. Thank you very much. Peace and love to one and all. History of equity and the equitable maxims. Equity will not suffer a wrong to be without a remedy. The role of equity is to supplement the common law and to provide remedies where the common law remedies are inadequate or non-existent. The court of equity was the court of the king's conscience. Impossible to make a law that is universally apt. There is always bound to be a case where the rule results in unfairness. These are the cases where the court of equity provides a remedy. 1858, reception of UK law. Law and Equity Act 1873, fusion of law and equity merged into the High Court of Justice, also merged all together at the same time. Admiralty, probate, matrimonial came to via Law and Equity Act passed 1879. The merger into the common law, which we found 2 and a bit years ago, into the CPR of the equity rulings in with the common law. So the equity was there within the civil procedure rules, court procedure rules, but we didn't know, and it was hidden whilst we're running around going Article 61, Magna Carta. We're not the debt, we're not the surety, we don't have an international treaty, documents with mixed jurisdictions on, no thumbprints and no autographs, no correction of trusts. We was in a really bad way. I don't matter which way you put it, We was doing bad. We was very retarded in our ways of acknowledgement and what has happened here, our encapsulation. We did say that it was fraud initially, but as the further we get into it, it looks like a very, very clever a setup for business and management of infants under. I'm not saying it's right. I'm not saying it's okay. I'm just saying that Latin mottos that say things that make man's head, ping. Fusion of law. Section 44 of the Law and Equality Act codifies the principle of the Earl of Oxford 1644 case. If the rules of equity and law conflict, equity will prevail. Equity prevails. The Adjudicator Act has since been added to this butte this year. So learn and make these 20 equitable maxims your best friend. Here we go again. Equity, number one. Equity sees that as done what ought to be done. Number two, equity will not suffer a wrong to be without a remedy. Number three, equity delights in equality. Equality is equity. Acquiescius est quasi equitas. Number four, one who seeks equity must do equity. Number five, equity aids the vigilant and not the indolent. Number six, equity imputes an intent to fulfill an obligation. Number seven, equity acts in personam, i.e., with man, not on objects. Corporations cannot act in personam. Number eight, equity abhors a forfeiture. Yes, it does. Number nine, equity does not require an idle gesture. Number 10, he who comes into equity must come with clean hands. Number 11, equity delights to do justice and not by halves. 12, equity will take jurisdiction to avoid a multiplicity of suits. Number 13, equity follows the law. 14, equity will not assist a volunteer. 15, where equities are equal, the law will prevail. 16, between equal equities, the first order of time shall prevail. First in time, first in line. 17, equity will not complete an imperfect gift. 18, equity will not allow a statute to be used as a cloak for fraud. 19, equity will not allow a trust to fail for want of a trustee. 20, equity regards the beneficiary as the true owner. Now, equity was given by the Lord. Lordy, lordy, lordy. The world, the res. Plan, et, the plane, t, the res. Christians, beneficiaries. So, how have we moved on? How is now the land that was given by the all Lord, Creator, God, grantor of dominion, Lord God, be careful of that one. How has that now turned into real estate with license and profits? Incredible, isn't it? Maxims of law. There are 10 essential maxims on the precepts in commercial law. 1, workman is worthy of his hire. I've had some claims about me, about man, where they've said I'm not worthy, that I copy, that I get stuff wrong. Yeah, I do get stuff wrong, and I do copy from others, and I name them, I promote them, I go back. I've just read stuff that's hundreds of years old. Obviously, I wasn't around then, so it's been copied from further publications. All those that are educating and on self-initiation have to copy from somewhere, a vetted, validated, trusted source. Here we are. So we're moving on. Number 2, the second maxim is equality before the law, or more precisely, all are equal under the law, God's law, moral and natural law. Exodus 21, 23, 25. Leviticus 24, 17, 21. Deuteronomy 1, 17, 19, 21. Matthew 22, 36, 40. Luke 10, 17. Colossus 3:25. No one is above the law. This is founded on both natural and moral law and is binding on every man. For some to say or act as though he is above the law, it is insane, immoral, heinous, and criminal. This is the major insanity in the world today. Man continues to live, act, believe, and form systems, organizations, governments, laws, and processes which presume to be able to supersede or abrogate natural or moral law. But under commercial law, remember the sea the land, the air. You see why I did that? Here we go. Man continue, but under commercial law, natural and moral law, let's go land law, sovereign, trade, private, are binding on everyone and no one can escape it. Commerce, by the law of nations, ought to be common and not to be controverted into a monopoly and the private gain of the few. The Club of Rome. This one is one of the most comforting maxims one could have, and your foundation for your peace of mind and your security and your capacity to win and triumph to get your remedy in this business, in commerce. Truth is sovereign. Exodus 20:16, Psalms 117:2, John 8:3-2. If truth were not sovereign in commerce, i.e., all human action and interrelations, there would be no basis for anything, no basis for law and order, no basis, no accountability, no liability. There would be no standards, no capacity to resolve anything. It would mean anything goes, each man for himself, and nothing matters. That's worse than the law of the jungle. Commerce, to lie, is to go against the mind, the ment. Oriental proverb, of all that is good, sublimity is supreme. 4. Truth is expressed in the form of affidavit. Leviticus 5:4-5, Leviticus 6:3-5, Leviticus 19:11-13, 1:1-1-3. Leviticus 19:11-13. There's your 3 ones. Get that up for I want that one. I should have noticed that. Numbers 32, Matthew 5:33, James 5:12. An affidavit is your solemn expression of your truth. In commerce, an affidavit must be accompanied and must underlay and form the foundation for any commercial transaction whatsoever. There can be no valid commercial transaction without someone putting their neck on the line and stated, this is true, correct, complete, and not meant to mislead. When you issue an affidavit, it is a two-edged sword. It cuts both ways. Somebody has to take responsibility for saying that it is a real situation, and it can be called a true bill, as they say in the grand jury. When you issue an affidavit in commerce, you get the power of an affidavit. You also incur the liability because this has to be a situation where other people might be adversely affected by it. Things change by your affidavit in which are going to affect people's lives. If what you say in your affidavit is in fact not true, then those who are adversely affected can go back at you with justifiable recourse because you lied. You have told a lie as if it were the truth. People, depend on your affidavit, and when they have lost because you lied, 5. An unrebutted affidavit stands as truth in commerce. 12. Peter 1:25, Hebrew 6:13-15. Claims made in your affidavit, if not rebutted, emerge as the truth of the matter. Legal maxim, he who does deny admits. 6. An unrebutted affidavit becomes the judgment in commerce. Hebrews 6:16-17. There is nothing left to resolve. Any proceeding in a court, tribunal, or arbitration forum consists of a contest or duel, a battle, duel, parlement, parlay with the mind, duel, duality, yin and yang, left and right, blue and red, public, private, yes and no, liability, no liability. A duel of commercial affidavits wherein the points remaining unrebutted in the end stand as truth and matters to which the judgment of the law is applied. 7. In commerce, for any matter to be resolved must be expressed. Hebrews 4:16. And there's more. Phil, 4:6. EPH, I can't even say that one, I forget now. 6:19-21. No one is a mind reader. No, I can't read. Yeah. You have to put your position out there. You have to state what the issue is, to have someone to talk about and resolve. Legal maxim, he who fails to assert his rights has none. That's not nice. That's wrong. The primary users of commercial law and those who best understand and codified it in Western civilization are the Jews. This is Mosaic law. They have had far more than 3,500 years past, which is based upon Babylonian commerce. This one is he who leaves the battlefield first loses by default. Book of Job. Matt 10:22. This means that an affidavit which is unrebutted, point for point, stands as a truth in commerce because it hasn't been rebutted, and the judiciary, justices of the peace, the judge, as the banker has left the battlefield. Governments allegedly exist to resolve disputes, conflicts, and truth. Governments allegedly exist to be substitutes for the dueling field and the battlefield for such disputes, conflicts of affidavits of truth are resolved peaceably, reasonably, instead of by violence. So people can burning and riots, yes? So people can take their disputes, and man has a dispute, yeah, not people, into court. People appeal and dispute into court and have them all opened up and resolved instead of going out and marching 10 paces and turning to kill or inquire. Legal maxim, he who does not repel a wrong when he can occasions it. Number 8, sacrifice is the measure of credibility. No willingness to sacrifice equals no liability, responsibility, authority, or measure of conviction. No signature on a letter, no liability. Here we go. Nothing ventured is nothing gained. A person must put himself on the line, assume a position, take a stand as regards to the matter at hand, and one cannot realize the potential gain without also exposing himself to the potential of a loss. One who is not damaged, put at risk, or willing to swear an oath on his commercial liability to claim authority. Acts 7, life, death of Stephen. For the truth of his, I know who Stephen is now. I didn't used to know Stephen, but now I know Stephen. Do you know Stephen? Not shaking Stephen, Stephen. For the truth of his statements and legitimacy of his actions has no basis to assert claims or charges and forfeits all credibility and the right legal maxim. He who bears the burden ought also to derive the benefit. 9. Satisfaction of a lien. In commerce, a lien or claim can be satisfied in any one of 3 ways. Genesis 2-3, Matt 4, Revelation. By somebody rebutting your affidavit with another affidavit of his own, point by point, until the matter is resolved as to who is correct. In case of non-resolution, you convene a sheriff's common law jury based on the 7th Amendment, USA, concerning a dispute. We talk about UK, Anglo, England and Wales later. Concerning a dispute involving a claim of more than $20, or you can use 3 disinterested parties to make judgment, 3 good men. The only other way to satisfy a lien is to pay it. Legal maxim, if the plaintiff does not prove his case, the defendant is absolved. Number 10, so the 10th maxim of law is a lien or claim can be satisfied only through a rebutting affidavit, point by point, resolution by jury, or payment. Conditional acceptance, or lien or claim. A claim can be satisfied through conditional acceptance as well to remain in honour. That's not a new maxim, but that's the way that we see the management of law. Commercial law, management of claims in law upon your person, capital name. Commercial law is non-judicial. This is prejudicial, not prejudice. This is timeless. This is the base, the foundation beneath which any government or any of their court systems can possibly exist or function. That means what the courts are doing and what all governments are ultimately adjudicating and making rules about are these basic rules of commercial law. When you go into court and place your hand on the Bible, you say, or you would say, I swear the truth, the whole truth, and nothing but the truth. You have just sworn a commercial affidavit. It is the conflict between the commercial affidavits of truth that gives the court something to talk about, that forms the entire basis of its action and its being there, in their venue, in our venue. Hence, one of the reasons attorneys always create a controversy or controversies. No court and no judge can overturn or disregard or abrogate somebody's affidavit of truth. The only one who has any capacity or right or responsibility or knowledge to rebut your affidavit of truth is the one who is adversely affected by it. It is their job, their right, their responsibility to speak out and free themselves, to issue their own affidavit, because no one can speak it for them. No one else can know what your truth is, or what has free will responsibility to state it. This is man's job and man's alone. We cannot do it. David can't do it. SPLspro.com can't do it. We have to teach it you this way, and you unfortunately have to do it. It is the way, it is the only way you can get there. Your responsibility to state it. This is your job at commercial law. This phrase designates the whole body of substantive jurisprudence, i.e. the Uniform Commercial Code, the Truth in Lending Act, applicable to the rights, intercourse of persons engaged in commercial trade, now not private trade, or mercantile pursuits. Black's Law 6th edition. Commercial law maintains the commercial harmony, integrity, and continuity of society. It's also stated as to maintain the peace and dignity of the state over the millennia. These principles, principality, principle, surety, debts, these principles have been discovered through the experience, and distilled and codified into those 10 fundamental maxims listed as I've just read to you. There is no legal issue or dispute possible which is not a function of one or more of these principles. The entirety of world commerce now functions in accordance with the Uniform Commercial Code, UCC, the United States Corporation version of the commercial law. The United Kingdom also operates under UCC as well. We'll get to that later. We've covered that before. A collection and how to calculate your damages. Now, here is another aspect of your affidavits in commerce. There is the assessment aspect, which is one who owns who and what and why, how and for what reasons. And there is the collection aspect. The collection aspect is based in international commerce that has existed for more than 6,000 years, okay? Nothing new under the sun here. Again, this is based on Jewish law and a Jewish period, which is in units of 3. I think this is a repetition from their publication. It's ringing true already. 3 weeks, 3 months. This is why you get the 90 days letters from the IRS. Commercial process are non-judicial. They are summary processes, short, concise, without a jury. Do you get that? Okay. The collection aspect, which is in units of 3 days, 3 weeks, and 3 months. This is why you get 90-day letters from the government. Commercial processes are non-judicial. They are summary processes, summary judgment, short, concise, without a jury. The IRS tax office creates the most activity of commercial collection in the entire world. The collection processes is relatively valid, although IRS tax offices agents are not registered to do business in any state. Did you understand what you just read? The IRS is not registered to do business or perform commercial matters in any state. So how do they get all the money they get? Answer: because you give it to them without requesting proof of claim from them, even if they were licensed to give you offers based on arbitrary estimations. However, this is where things get interesting. The other phases of matters is the assessment phase. There is no valid assessment. The tax office has and never can, never will, and never could ever issue a valid assessment, lien or levy. It is not possible. First of all, in order for them to do that, there would have to be paperwork. A true bill in commerce, there would have to be a sworn affidavit by somebody that this is true, correct, and complete, and not meant to deceive, which in commerce is essentially the truth, the whole truth, and nothing but the truth. You can't handle the truth. Yes, you can. I'm giving it to you now. We continue on. When you get into court, nobody in the tax office is going to take commercial liability for exposing themselves to a lie and have a chance for people to come back at them with a true bill in commerce, a true accounting. This means they would have set forth the contract, the foundational instrument with your signature on it, in which you are in default, and a list of all the wonderful goods and services that they have done for you, which you owe them for, or a statement of all the damages that you have caused for them, for which you owe them. To my knowledge, no one has ever received goods or service from the tax office, IRS, from which they owe money. I personally don't know of anyone that has damaged anybody in the IRS that gives them the right to come after us and say that you owe us money because you damaged me. The assessment phase in the IRS is non-existent. It is a complete possible deception and fraud. Wait a minute, there is one definition of the service that actually applies to the IRS. Service, the act of bringing a female animal to a male animal to get, so that the owner of the animals may enjoy the products of this union. This is why the rules of commercial law come to our rescue. T.S. Eliot wrote a wonderful little phrase in one of his poems. We shall not cease from exploration, and the result of all our exploring will be to arrive at the place at which we began and know it for the first time. This is the beginning and this is the end. This closes the circle on the process. One reason why the super rich bankers and the super rich people in the world have been able to literally steal the world and subjugate it and plunder it and bankrupt it and make chattel property literally out of most of us is because they know and use the rule of commercial law and we don't. Because we don't know the rules nor use them, we don't know what the game is, we don't know what to do, we don't know how to invoke our rights, remedies and recourses. We get lost in doing everything under the sun, S-O-N, except the one and only thing that is the solution. No one is going to explain to you, me, I, the family, what and how all this is happening to you. That is never going to happen. These powers that have left, that have not divulged the rules of the game, the monopoly, they can and do get away with complete deception and fraud and steal everything, including assets of blood, because no one knows what to do about it. Solution, you need to issue commercial affidavits. You need to consider, no instructions or advice here. You don't have to, don't have to do anything, but you can consider. You can assert yourself in an affidavit, statement of, intent, truth, plain simple facts. I have never been presented with any sworn affidavits that would provide validity to your assessment. It is my best and considered judgment that no such paperwork or affidavit exists. At the end of this document, you put your demands on them or requirements, and requests can be denied, so we don't go requirements, yes. Wishes. What do you want? Wants can be denied. So at the end of this document, you must put your demands on them. They must be implicit. And then you state, should you consider my position in error, you know what they have to do now, don't you? They must come back with an affidavit which rebuts your affidavit point for point, which means they have to provide the paperwork with the real assessment, the true bill in commerce, with real sworn affidavits that would make the assessment or claims against you valid. Yesterday was St. David's Day. To all the other Davids out there, happy belated St. David's Day. Speaking of affidavits, for yesterday, no agent or attorney of a fictitious entity can sign an affidavit for a corporation. How can they swear as a fact the corporation has done or not done anything? They do not have the standing. They cannot and never will provide you with this. This means your affidavit stands as truth in commerce. That's what they see, crux of it there. You can even make it more interesting if you like. You go to all their laws like Title 18 and you tabulate the whole list of crimes they have committed against in lying to you, deception, so forth and so on, assumptions, foreclosing and selling your home and issuing lien and levies. This could be quite an impressive list. I'm going to skip all of that out because this is just speculatory chat. It's not concise. Right. An arrest for failure to appear where no man, only a trust account was ever charged is a violation of human rights under the International Bill of Human Rights, IBHR. Article 9 of both the Universal Declaration of Human Rights, UDHR, and the International Covenant on Civil and Political Rights, ICCPR. Show me the law which proves I have to go to court, or show me the paper I signed which proves I agreed to. Neither exists. Under the IBHR, UDHR, number 6, and ICCPR, number 16, we have the right to be recognised everywhere as a person before the law. We have also the right to waive that right, as in Canada and the States are both signatories to the IBHR, so then all court officers are bound by this international law, which trumps all other laws, which are only corporate statutes. Important. Rewind, selector, and play again. The entire court system is commercial, UCC, ecclesiastical, maritime, admiralty. Under the guise of a crime, the Crown prosecutor charges the named trust account, not the man, and a constructive trust court case is created. Only trustees who have legal title to the trust can access trust funds, but only via the authorization of the beneficiaries, us, who would have the equitable title, who should have the equitable title. But we haven't. They've used the name in commerce because of the constructed setup. The only changes we authorise are the ones for our benefit, as Andy and I have previously said. Maxim of law: the one who creates the liability must provide the remedy. This means that the prosecutor is able to lie for unauthorised charges against the trust. So the prosecution is in violation of criminal breach of trust and obtaining execution of valuable security by fraud. They do not want to be liable for their debt to our trust accounts. Equity thieves, that's what they are, this Club of Rome, equity thieves. They do not want to be liable. They unjustly usurp, subjugate, subrogate, enrich themselves, and then, by deceiving us into acting as a trustee, surety, via intimidation, threat, coercion, and to some extent fraud, force us to pay our debts to society one way or the other. No case has ever anything to do with justice. It is all about accounting, surety, money, and the court never has jurisdiction. The entire case is as I say it there, as I see it there. That's it. I'm done. It's Saturday. It's my day of rest. I enjoyed that. That needed to be said. I purposely said it firmly. I had an affirmation about me, and I did that on purpose. I said it with gusto. I hope I didn't shout it too loud. 25 on a Saturday afternoon. Thank you for that. You can take this information, this intellectual knowledge is not mine. It's not stolen. It's rightfully the property, the proper tie, the intrinsic intellectual value there is valueless. You cannot put a value on that information. The age of Aquarius, the picture pouring. Tomorrow with Josh, we're going to come out with a legal list of common phrases, words, adjectives, nouns, pronouns, prefixes, suffixes, etymological roots. We're going to bunch them up. Then we're going to look at the correlation of the numbers, the letter, the physical, ethereal, master, right, left, everything. So I'm very excited, to say the least, about linking up with the X-Man tomorrow. The camera is going off. We'll keep the mic on. We're rolling a cigarette, and I'm sitting with my queen and the princess downstairs. Again, you want in on this. You want this. You want this to happen. You want it fast, and you want to help us. We are promoting as fast as we can for help, for the donations, for structuring the new trade as man and land, beneficiary upon the land. Yes. And you have the law, you have the ecclesiastical, and you have the legal. You have the right to choose. You have the right to be duly informed. You have the right to, as I've said, in all of that. So that's just to correlate with brother Andy. We are a family. We are a team. I'm not aware of what Andy's about to bring out some days and weeks. Yeah, he moves on his own discovery and using his due diligence. What I'm doing is working by backing up. I'm getting exemplars and questions, and I've answered half of them. I'm going to get to some more tomorrow, and notifications and .coms and so forth. But Andy's doing an exemplary job. I'm immensely proud of the man. I'm so happy that we are where we are. I'm so happy that he's able to do what he's doing, and in confidence, and you're accepting it and you are following it. So it is a grandeur now. Gesture. Here's a kiss. Hello, remember me. Hi, I'm David. All is quiet. Good. I'm going to, 15 minutes and then we're chilling out. We're wrapping up. You see the comments. You can chat on there if you want. Have a read. Anne-Marie, get in the chat room. Family business. We are a family. That's my family. I sacrifice my time to give you this and to say, thank you to Brother Smithy, Abel, Danger live stream, which would be Field now. It's locked in as Field. Yes, you can if you want, Yanka. You can say hello, everyone, if you want. The next one from Indy is from the Princess Yanka, saying hello to the sovereign Famalan. I needed it to put the light in. There you go. Light's gone in kitchen. That's no good. So yeah, truly incredible. That's taken from many and various publications, and I couldn't get them to you now. They are all on the .com, and we will go through later on with further talks about references, your input, what you see, how you see it, what you want further coming, and working together. I haven't got any information on March yet. I've said provisionally that I'll go, so we're working it out as we speak. And Andy, Gobsmack, Field, I'll leave it to them, and I will meet up with them in due course. So stand by, nothing to report as of such. Andy may have some, and yeah, we will see. We will see. Exciting times. I'm now going to read your comments. I need to find a light bulb. Find a light bulb. Now with me, family. This one has blown. Get your comments in. We're wrapping up in the next 20 to 30 minutes. Got anything to say or add? And then get it in now. Shadow, if you're here, I'm expecting commentary. Light. Let there be light. 113. So yes, I did read that at slightly a faster speed than desired. You have the ability to slow down YouTube videos 50%, 25% if need be. Slow me down and all will be good. This is my time. I need to utilize it effectively. So sorry if I went a bit fast for you. If you have what's called an indie headache, I've bestowed much there. I give it you gladly. Check it out. Thank you for the session today. Been an excellent Saturday. Thank you, John, for all of your input. I have created
You won't let me, that's the thing.
No, but you could have done it earlier today. I think we're back. Here we go. I'm linked back up. The link up is on.
Phone is constantly restarting. It won't come back to home. I've had a phone, a handset is blown. My other backup auxiliary Android is constantly restarting. So I don't know what we've done there, fam. That unit is now gone. Another handset blown, Smithy. Let me know if you get any grief, anybody. Told you the strange things are happening. They'd cut my sound on the first cast. So, yes, this wasn't meant to get out. I don't think they want it out. Oh, another phone. You know what? I've probably gone through 10 phones in 2 years. Black screens, reboots, kicked out. Yes, done nothing wrong. Man under God, covenant of. I'm obligated to release this information. I can't sit and let it collect dust. I'm not going to sell it. We have got to use the monetary system that we're in to our advantage, as pointed out in that video there. So I can't see your comments right now. I'm just starting up a different handset, saying a little prayer, and then I will get to the comments. And I'm signing off. So sovereigns, stand by. Just booting up. We are being monitored. We are not doing anything wrong. And like I say, it's your time to decide, YouTube. You must decide on what's happening. And you must decide on your destiny. I'm not telling you anything. I'm not giving you legal advice. No man can judge. All men are created equal. And we've shown you as best as we can where we're at and why. And now this is further. Yes, it's on. We've got another one up. Further endorsement, validification, exploratory avenues, and justification of why we are saying and doing what we're doing and how we understand, overstand now, and see you all confused, a bit like going deep into a human biological, organ, and seeing all of the bacteria and blood cells and oxygen cells and pathogens all moving around, and it looks like craziness. That's what we're seeing right now from an overall picture of society. We step back and we're looking at it. I said to Smithy, I'm going to do a cast today. We'll do one Sunday. Kevin, Andy, myself, Josh. We'll get G-Star on the digital side, and the Phi Cycle will come together tomorrow. This is just supplementary. For me, I call it enjoyment. I enjoy giving this information out. I enjoy speaking. Man speaks too much. So yes, I'm sorry it's late. This is supplementary to the first tier of the educational foundation coursework that we've released there. Key competence is what you need, and you don't know. And if you don't know, then that's where the problems arise, as we've pointed out further throughout this video. Previously throughout this video. Here we go. I'm just trying to get my channel up and look at the comments. What a sesh. It's a pleasure though. It's my day of rest. It's what I do for fun. And the boys will be all in the house tomorrow evening. Kevin, Andy, David, Josh, G-Star in the wings. I do hope. Shadow. We to leave their system using the principles of international law. Equity looks to the intent rather than the form. Enactments. Oh, yes, John. Jerry, bad signal. Oh, I got to that bit. I need to scroll down then. Okay, Chill Star. 13 popes, named Leo. Oh, aye, numbers. Thank you, John. Leo 1, the great pope. 44861. Oh, nice, nice, John. Lisa, happy is the man that findeth wisdom, and the man who getteth, that's a Sheffield, getteth understanding, for the merchandise of it is better than the merchandise of silver, and the gain thereof and fine gold. Proverbs there, 1 3 1 3 14. Thank you there. No, that's not what I said. My one was 3 1s and a 3, but that's close enough. I'll take that. Thank you. Affiliate in grammar, not without both negative. What part of the alphabet realm am I to today? Maybe tomorrow then. Seeking, yeah, I got to there. Bonjour. I said I have creator and my phone went blank. Yeah. Abbreviation symbol. Yes, yes, yes. The IRS doesn't really exist. It's a false statement. Hasn't taken to be true. So yes, well said, John. I'm glad you've got clarity. MG, afternoon. Yes, peace and love. I can't slow down a bit. You slow me down on YouTube. This is my time. My time is finite. I have a lot to do. I have a lot of material. You slow me down on YouTube. Said this before. Sorry, got stuff to do. Too many jobs. 180 emails, updates on the .com. I'm not going to go on about it. You're all proficient with my time and how little it is. What is the document you are reading on? To be coming from the .com. Don't worry, Lisa. You're interested in this? We'll be chatting about it. .com in the forthcoming. Andy and I will be bringing that to you. Thank you, MG. Thank you, Andy. John. FPV. Aha, Captain. Kev. I have the ability now to read complex words. I wrote an email out to a brother called Michael whilst I was talking to brother Ben. And I sent the email to brother Michael after I had an hour and a half chat with brother Ben. And then when I finished with Ben and I rang Michael, I says, what do you think about that email? He went, that's blinded. I'd like to change one word, this one to that one. I went, okay, anything else? He went, no. I went, well, I've just been chatting to brother B and I've written that out whilst chatting to B. You see me on the channel talking to you whilst typing a message out to Anne Marie. My brain has gone to the next level and you do need to slow me down. The silver water, the energizing of cutting out the meat, the pork, the video yesterday with Josh on Sun and Moon will elaborate more on what we are doing now. The candida extraction, the cancerous fungus extraction, the management of sugars, toxins, preservatives. Yeah, I need to be careful. I'm quite the amount of caffeine that I have. I'm getting more energized. I'm downloading more. And I do get a bit emotional, excited, giddy. That's part of me, though. That's my, Bernice, hello, sister. Albert, I have still lost access to SPL's Pro, David. Well, you should ring or text me. Here we are on a live YouTube cast on my day off. We've not had a text. I've not had a phone call. I've not had anything. And now I've got to be obligated to sort this out, which I will on a Saturday, which is my day of rest, doing office duties. Thank you for letting me go live on a cast, Albert. Next time, my personal number, a text message. If it's in an email, I am massively behind. We will catch up by the end of this weekend. I haven't got an administrator. I haven't got an excess of time. So it's quite frustrating. It's just one of us managing any loss of services or access, remedy, maintenance, and cure masters will make sure that you're looked after. So if we have got a tweak to be going off here, I will find out. You have got a lifetime membership, Albert. So rest assured, I will reinstate. All right, then. Been a week, bro, in the group. Okay, yeah, you can say sad face and you can moan. I am overloaded. I am trying to start something that is, in principle, cutting edge, on point, not heard of, new technology, new website. So please bear with me, brother. I will make it up to you in every way that I can. Is there anybody else with issues on the .com whilst we're here? I will take a list and effect them immediately. I know you're not moaning. I know, brother, I love you to bits. I will always love you. And all of the subscribers, future, past and old, ones that have gone, shills and trolls, still got the love for the streets, for all of them. There's no hatred, there's no anger, there's no malice. There is frustration, there is anxiety, there is pressure, there is expectations, there is honour, there are duties, there is justice and law, and all things that are good and right. And that's where we're at. So thank you, yeah. You get in touch with me. No rush. Well, it's been a week and we've put it on there. So my customer services, Choob and everybody do need to be improved, as highlighted by brother Albert. And yeah, I do believe Jay, if he was on here now, I have tended to his issues and there has been some log on access, padlock, renewal issues. So I've renewed and given lifetime accounts to everybody up until March. I'm having to do it manually when we've got several hundred. That's another task that I've been coming home straight from work and then managing on with. So for your benefit, man's up at 7:30, out of the house for 8, on the job for 9:15, constantly grafting with now don't eat, a fast, don't have a break, get back for 5:30, 6. Then I start munching and getting onto the job, doing consultations. Then it's 10 o'clock and it's back to bed again. So it is tight, it is full. We do need sponsorship, endorsement, donations, help, agents, operatives, trustees. No, we don't do trustees because you've got the legal title and you're responsible. So we have agents. We're working in that private trade capacity in law. If you have emailed me offering, I will be taking you up and you will be hearing from me, no doubt, by 8 p.m. Sunday tomorrow. And thank you all. And much love. We give it with love. We do it with pride and honour. We're not perfect, not an expert, and we are continuously improving. You'll be pleased to know, Albert. So, as part of my promise and honour and duty, I will sort that out in the next couple of hours. Check your email box for clarification, notification, verification of the ions there, all ion words. And tomorrow we will be back with a boom, a sonic boom, a phonic boom. Josh, David, Andy, possibly Greg, me and the X-Man are confirmed. G, Andy, and Kev. I'm not sure unless they've commented on here. Yes, God loves a trier, Andy, and we are indeed trying. We are being tried in judicial realms. We are losing. We are being gutted. God loves us. God loves you, brother, for the good work that you've done. I love you. I love you all. You see how hard it is. We're just five men at the minute. The FI cycle. We'd like the female form. We'd like help. We need help, and we will manage it. But I'd like to now move forward this year, boost fit baby, and let's propel it into the areas that we are more than capable of going. Thank you for your continued patience, your support, your overstanding, innerstanding, understanding. I realise this video is quite a hefty one, and it's if it was, indeed a weapon, it would be a cannon. And thank you very much, and peace, love, and light. Once. No, that's all right. No, that's right. Thank you then. Yeah, we're going to end it now. My time is finite, Lisa. Yes, that's why I've rambled it out so fast. To say slow it down. All our time is valuable and finite. Not just mine, all of us. We're all equal. We're all created in the image of. Now let's rise up and take our positions. Let's get alive, become confident, and start compelling with the spelling. Ciao bello.